Hello, welcome to the website for ERISA Fiduciary Administrators. We also go by EFA or just EFA. My name is Philip Koehler. I'm the firm's founder and CEO. We created this website for persons who work with their company's retirement plans, especially the inside fiduciaries and non-professional fiduciaries. Like most websites, this website is a work in progress. In this introductory video, I'll review the firm's business model and explain how our work frees up the corporate executives who find themselves in a fiduciary role, shelters them from exposure to fiduciary liability, and reduces the costs of maintaining the plan in many ways. Then I'll discuss a widespread problem in fiduciary governance, one that I've seen many times and one that almost always blindsides employers. And then I'll suggest a few remedies. First though, let me give you a quick sketch about my background. I have spent my entire 40-year career in the employee benefits industry. I began as a pension underwriter on the administrative and investment side of the industry, working for large insurance companies, the Travelers, Pacific Life, and John Hancock, and then I moved on to the management of third-party administration firms. In 1991, I was admitted to practice law in the state of California and began a legal practice as an ERISA attorney. Some of the firms that I've worked with include the law firms of Morrison & Forster, Jeffer Mangels, Butler and Mitchell, and the accounting firms of Deloitte and KPMG. Over the last 22 years, I have represented thousands of plan sponsors in matters such as plan design, ERISA litigation, fiduciary governance, and tax compliance. You can find out more about my background by clicking on the button Meet Our CEO above. Now let's focus on what makes EFA's business model so innovative. For starters, I think it's best if I tell you what we're not. EFA is not an administrative service provider like a record keeper or a third-party administrator. So our engagement does not disturb the current vendor footprint. We're not a broker-dealer, investment manager, or investment advisor. We don't sell any products. We're not paid fees based upon the total value of the plan assets. Our fee structure is strictly a flat dollar fee arrangement negotiated with the plan sponsor. EFA maintains a strict code of independence. We do not have affiliations with or accept compensation or benefits from any vendor providing services to the plan, or for that matter, with any person or entity in the financial services industry, whether or not they're providing services to the plan. And that would include banks, insurance companies, mutual fund companies, third-party administrators, et cetera, et cetera. Now let me tell you what exactly EFA is all about. EFA is an independent fiduciary for plan administration. In our standard engagement, we accept the outright delegation of fiduciary responsibility to act as the plan's official plan administrator, as defined in Section 316 of ERISA. While the plan's vendors, auditors, outside counsel, and consultants will strongly resist any notion that they are or would ever become fiduciaries, EFA actually embraces that role. As plan administrator, our principal function is to oversee and manage the plan's administrative vendors, ensuring that they work collectively to maintain the plan's operational compliance and that the plan pays them no more than reasonable fees for their work. EFA scrutinizes each vendor service agreement and fee arrangement. Where appropriate, we will conduct a competitive bidding process based on a uniform RFP and benchmarking of applicable fees. We make sure that the services each vendor provides are the services that are required by the plan in accordance with its terms, and that the work provided by the vendors is both timely provided and accurate. As an attorney practicing in a law firm, I realized that most of my involvement with a client's plan came about in reaction to a problem that had arisen one way or another. I created EFA to give plan sponsors the option to outsource the plan administrator role and the fiduciary responsibility that goes along with that, so that I could bring my expertise to bear in a proactive managerial style of interaction with the plan rather than just putting out fires. ERISA Fiduciary Administrators regularly evaluates vendor performance before problems arise. For example, in some situations, we will negotiate lower fees, curtail the vendor's services, or recommend its outright replacement based on the relevant facts and circumstances. We go further. In our standard engagement, we act as legal counsel to the plan. Thus, we take responsibility for the review and analysis and negotiation of all vendor agreements to the extent that the fees are paid by the plan. We also review all proposed amendments to the plan document or any of its governing instruments and advise as to the impact on the roles performed by the plan's fiduciaries. We manage fiduciary committee meetings, maintain the committee meeting minutes and records, and keep all inside fiduciary apprised of relevant legal matters. Outsourcing the plan administrator's role to ERISA Fiduciary Administrators has many more advantages. You can gain greater insight into our business model by navigating around the firm's website. Let me close now by discussing a common fiduciary problem, one I've seen many times. It's a big one, but it's very easy to detect. Look in the definition section of your company's plan document. Specifically, look at the definition of the term, quote, plan administrator, end quote. In my experience, it's likely to designate the corporation as the plan administrator. If that's the case, the U.S. Supreme Court concluded long ago that in the absence of a clear delegation by the company's board of directors to other parties, such an ambiguous plan term should be construed to mean that the corporation's board of directors is the plan administrator, and therefore each director is a fiduciary subject to the full range of fiduciary exposure. As anyone who has ever served on a board will tell you, this is almost certainly not what the board intended when they approved adoption of the plan. The board is not designed to function at this granular day-to-day level of detail about something so complex as the company's 401k plan. Many directors simply lack the subject matter expertise to take on a fiduciary role. Some may feel that they have inherent conflicts of interest, but almost all of them will tell you that they simply lack the time to devote to such an endeavor in the first place. Compounding the problem is the common misperception that many plan sponsors have that the plan's TPA, third-party administrator, or broker-dealer, or a mutual fund providing record-keeping services has somehow accepted the delegation to act as plan administrator. Having reviewed thousands of vendor agreements, we know that these documents are not models of clarity, and there's little wonder that plan sponsors misconstrue them as delegations of fiduciary responsibility. Invariably, however, buried in the fine print of these agreements are numerous representations that the service provider is not a fiduciary and is performing only ministerial and non-fiduciary functions. The typical agreement even includes an indemnification provision in which the plan sponsor holds the vendor harmless from any damages that result from fiduciary breach claims. So where does that leave the plan? Well, first it leaves the directors unaware of their exposure to fiduciary liability and therefore not covered under the company's fiduciary liability insurance policy, so they're both blind and naked. Second, there's no one affirmatively acting as the plan administrator because the relevant parties think someone else has that responsibility. It's a classic finger-pointing problem. Vendors rarely disabuse the plan sponsor of its confusion on this issue until a dispute arises. This means that vendors are typically acting without appropriate oversight over their work or their fees, which is a situation with a very real potential of ending badly for all concerned. If your company's plan defines the term plan administrator in this way, it should waste no time in getting the directors properly covered under the fiduciary liability insurance policy and then consider the best way to replace them with inside or independent successor fiduciaries. ERISA Fiduciary Administrators, of course, is available to assist you with troubleshooting this problem. Even if you would prefer not to engage EFA to take on the role of plan administrator directly, we can assist you on a strictly consultative basis. Thank you for listening. I hope you'll visit us again to check the updates and perhaps respond to a blog post. If you have any questions, by all means, give us a call, shoot us an email, and please feel free to connect with me on LinkedIn.